Good morning, Ms. McChesney.
Good morning, Your Honor. May it please the Court. My name is Elaine McChesney. I'm here with Jason Watkins. We are representing Fleet National Bank, which by operation of merger and by law is now Bank of America, but has been referred to throughout the proceedings as Fleet. This is a question that arises under Article 4 of the UCC, and which should have been a relatively simple legal issue established by the legislature in Article 4, Section 4-201. The issue is, what do you do in a connection with a foreign check collection where a customer brings the check denominated in a foreign currency to a bank? In this case, Fleet, purely a collecting bank. A collecting bank has no responsibilities with respect to the check other than to exercise due care, ordinary care, as that care is defined in connection with the custom and usage in the banking business in Boston.
Could I ask you a question?
Yes, Your Honor.
I guess it's two questions. Is it, and maybe it is Article 4-201, but is it the case that if, in this case, you have the teller saying you don't need to endorse this check, but then I gather there's a stamp on it saying prior endorsements guaranteed or something like that? I'm not sure if there's no endorsement on there what that means, and it goes to the German bank, and the German bank, I guess in your view, mistakenly declines to accept your stamp and sends it back. Article 4 says that the customer has no recourse in that instance?
In that instance, the customer has no recourse against Fleet.
Does it have a recourse against anybody?
Yes, it does. It has recourse against the correspondent bank in Germany who made the mistake. This principle dates back, as we indicated in our brief, 175 years to the Fabens case. And in the early days of the Commonwealth, or indeed the entire country, this was a very hot issue because there were no national bank systems, there were no collection systems. And if you were going to send a check or a check was drawn out in Springfield, literally somebody had to get on a horse and take it out to Springfield, and that was a foreign check collection. The problem was that banks were going belly up, which some are doing these days, and the question was, if you, as a collecting bank, sent it to another bank out in Springfield, which was supposed to send it on somewhere else, and the bank in Springfield failed, was the collecting bank responsible for the check? And the answer was no. You cannot have commerce where the collecting bank really has nothing to do with the transaction. It is not taking on any risk. It's not an insurer. It's doing this for a very tiny, tiny fee.
Well, but if it is your negligence that causes the delay, surely you would be responsible for that.
Oh, of course, and that's in section...
If the teller was negligent in saying that there was no endorsement necessary when in fact there was, isn't that your responsibility?
Well,
okay,
that's due care.
That's two questions. Right. Okay, two questions. Let me answer it. First, yes, if Fleet had been negligent, yes, of course Fleet was responsible. Second, was Fleet negligent? No. Both the trial court and the appeals court just got it dead wrong. There was no requirement for the customer to endorse. Now, the question that Justice Botsford asked about the endorsement, the bank put a stamp on it, and under operation of law, under the terms of the UCC, that was sufficient, okay? I want to point out something else. The endorsement is not required under the UCC for collection. An endorsement is only required for negotiation. This is not negotiation. It's very different. Presentment of a check, and that's what is occurring here. Presentment. Fleet, acting as the agent for Mr. Gossels, presented the check to the drawee, to Dresdner. Now, it went through another bank. Okay, it was also a cashier's check. Look at the check. There's a copy of it. That makes a big difference, too. Under Section 3501, presentment says it's a demand for payment. If asked, all that has to be done is that the person presenting the check shows some reasonable identification, or if, in the case of a collecting bank, they're acting for the customer, that they have authority. And there is no requirement that it be endorsed. Now, Section 3201 is the section of the UCC that requires endorsement for negotiation. And it also says that it does not require endorsement where it is a remitter, where it's for remitter. And in that case, what that means is it's a cashier's check. So the code expressly says that for cashier's checks, you don't need an endorsement, and it's clear. I mean, this is a check drawn on the bank itself. It's the payee bringing it in. He doesn't have to endorse it. Section 3-409 of the UCC.
How come? I'm sorry. I mean, I go to the bank all the time. They always make me endorse my checks. I'm just why am I confused here?
You don't have a cashier's check.
Well, even if I have a cashier's check.
The cashier's check is different, and it's different under the UCC, and in fact, under Section 3-409 of the UCC, it says that because it's a certified check, it has already been accepted by the bank. It's
cash.
It's cash, exactly, Your Honor. Thank you. And that is one of the reasons why the endorsement was not, in fact, required.
So this really doesn't have anything to do whether it's presented or negotiated. It's a remitter. It's what you call a remitter?
Remitter.
Remitter. Therefore, it's a cashier's check. Therefore, as a matter of commercial law, it does not need to be endorsed.
It does not need to be endorsed for all of the above reasons.
Ms. McChesney, is that in your brief? I just don't remember reading, but maybe I missed it, about cashier's checks and they do or don't need endorsement?
I don't know which brief it is in, but it was
certainly,
it may be in the application for further appellate review, but in fact, it was a cashier's check, and Mr. Gossels in his brief admits it was a cashier's check.
Okay. I have a question about damages. Did he present any evidence that he would be able to get a better deal from any other bank?
No, that's one of our points, is that it's not enough to say I could have covered, I should have covered, I could have gotten a better deal. There was no evidence whatsoever presented. And in fact,
then even if there were negligence, your argument is no damages?
No damages. And in fact, just as a matter of common sense, the euro, 1999, was a brand new currency. Banks do not keep vaults of foreign currency lying around. They keep a limited amount. If foreign currency is sitting in a bank vault, it's not earning money. It's not earning interest. There was no evidence that any other bank in Boston at that point in time offered euros, or in fact that there would be that many euros, 85,000 euros lying around if you took every bank in Boston.
That's one of my other questions, is that, and I would address this probably to Mr. Gossels, but why did he expect to be paid in euros to begin with?
Again, we have no idea why he expected to be paid, and we think that the lower courts got the presumption wrong. You're in the U.S., there is a U.S. statute that says the U.S. dollar is the legal tender here in this country, and everyone is presumed to know that. Now, if you go to a bank, they do not keep a running tally of your bank account in 2 or 3 different currencies. You do not have...
It's not 2 or 3 different currencies. By his argument, it's every currency in the world.
Exactly. And
I mean, I'll ask Mr. Gossels that, but it means that you keep Namibian currency and Chilean currency and everybody else's currency.
And banks cannot be put to that responsibility.
Or you get access to them, is his point.
Well, and if that is the case, if we needed to get access, then that desire needs to be communicated. You cannot hold a bank responsible for someone's uncommunicated desires. The other point that we make in our brief, and this is the deposit receipt that he got, it says here that we took the check and it's for collection, okay? And there are 2 little things you can check off. One is provisional credit, the other is for collection only. And both of them have a foreign exchange component to it. So clearly he knew that at some point, whether it was on October 15 or whether it was later on in the day, that it was in fact going to be converted to U.S. dollars.
What exhibit is that?
That is Exhibit 2 and 3 in the appendix at 277 and 278.
Ms. McChesney, if I understand correctly, the bank in Germany did not choose to pay in dollars, paid in euros, and paid you in euros at whatever the exchange rate was there on that day, right? Is that...
They transferred euros, not at an exchange rate. They just gave us
yes,
euros.
They gave, yes, okay.
Yes.
And then when you paid Mr. Gossels, you used the exchange rate on whatever that date was here in the United States or in Boston to pay him, right? So is there any, I must say I'm confused by the appeals court how they calculated what that differential is. I'm just wondering how you get
They were
there.
using the intern.
Okay, there is a reason for the confusion. The appeals court confused two different concepts about foreign exchange rates. Okay, one concept of foreign exchange rates, which the appeals court thought was going on here, where they're talking about a differential, they kept talking about the retail rate and the interbank rate, okay? Now, just like any kind of commodity, there is a wholesale price and a retail price. And the appeals court thought that that was what was going on here, and that is why there was a differential in the rate, and that's not true. Okay, number one, what happened is, you know, the currency fell, and it was no problem of Fleet that the currency decreased in value. Now, the other point that the appeals court got confused on is this issue about the UCC 3-107. Now, 3-107 says that the payor bank, which is the drawee, not Fleet, the payor bank, Dresdner in Germany, has the option to pay either at dollars or in euros.
Well, it just uses the word paid, but you say that means the payor bank.
It absolutely means the payor bank, and let me give you a couple of other sections of the UCC to guide you along your way. Okay, number one, Article 3, Section 102 says that it only applies to negotiable instruments, does not apply to money. Fleet was not negotiating this instrument. Fleet collected the proceeds. All Fleet ever dealt with was money. So number 3, Section 3107 just does not apply to Fleet at all. Section 3103 of the code defines drawee, that's Dresdner, as the person ordered on a draft to make payment, okay, not the collecting bank. 3-501, dealing with presentment, the demand upon a drawee to pay. The collecting bank doesn't pay. Section 3-601, an instrument is paid by the person obliged to pay the instrument, which is the drawee, not the collecting bank. Section 4-105, the payor bank is defined as the drawee bank, Dresdner. Section 4-215, final payment, means by the payor bank. Fleet was not the drawee, not the payor bank.
When, at one point, you cited Section 4-2052, where if the check is not endorsed, the collecting bank warrants to, among others, the payor bank, that the amount of the item was paid to the customer's account. Can you help me out with that? Does that say, or does that mean that by warranting to Dresdner that the amount of the item was paid to Gossels' account, does that mean that Fleet had given him a provisional credit?
No, it does not.
Why not?
Okay, because in order to give someone a provisional credit, you are giving them cash as of that date. Provisional credit is a loan. That's all it is. I come in with a check, I'm a good customer of the bank, and I say, can I have an advance? I am a good customer, I will make it whole later on.
But you're warranting to Dresdner, Fleet warranted to Dresdner, that the item was paid to Gossels' account.
Okay, that warranty is in case Dresdner later learns that this was a forgery or that we took the proceeds and never passed them along to Mr. Gossels. It's not a provisional credit. Provisional credit is a loan. And there is no requirement under the code or otherwise that forces a bank to make provisional credit available to any customer in a check collection. And that was, in fact, one of the criticisms by both the trial court and the appeals court. And they had said that because we did not check off one box or the other, that that was a misrepresentation and therefore held it to have been apparently a provisional credit. I will point out that provisional means exactly what it says. It doesn't mean final. And under the UCC, you are always subject to chargeback, just as if you deposit a check in your bank account and it turns out to have been forged or insufficient funds, they send it back. The bank, your bank, is not on the hook for that, and neither should Fleet be on the hook if, in fact, the currency fell. That is what happened here, and the UCC is very clear and has been clear because for 175 years, this court was the very first court in the entire nation to realize that that is the right risk allocation. And I also want to encourage the court to look at the amicus brief filed by the Mass Bankers Association, which I think lays out those policy reasons and the history very well.
Thank you, Mr.
Thank you.
Chesney. Mr. Gossels?
Good morning, Your Honor.
Good morning.
Members of the court, my name is Peter Gossels, and I'm appeared pro se before you this morning because I didn't have the funds to hire competent counsel for 7 years of litigation that's been forced upon me by Fleet Bank and now Bank of America. Actually, it's 9 years. I am here now looking for the money that they've converted.
Mr. Gossels, why
Yes.
did you expect to be paid in euros?
Well, I'm glad you asked that, because where's the statute? I just had it. The statute says that a negotiable instrument, I'm referring to Chapter 106, Section 3104.
Hold on one sec. 106?
106-3104. A negotiable instrument, like my check, is an unconditional promise or order to pay a fixed amount of money.
Wait, Mr. Gossels?
Yes.
Is this in your brief?
It is.
Okay, you
It
tell me
is.
where, page what?
Oh, that I'm not sure I could do.
Okay, I just can't find it.
Well, I think we have an index.
Yeah, I've got 3107. Forgive me, but it's helpful for me to be able.
Oh, absolutely. What did I say? 3104.
104, you said.
3104.
Anyway,
It's not listed in my index, but it's basic law. I mean, it's
I
and it came up here in the question for the first time. Why did I expect to find that? In my brief, I said I did expect it, and you asked why.
That's my
And the
question.
reason is this section was very important because it says it's a fixed amount of money. The fixed amount of money here was euros. So when I walked into the bank,
But we're not in
just
Europe.
let me
The
make-
fixed
That's
amount of money
correct.
here is
That's
dollars.
correct.
Yeah.
That's
Mr.
correct. But
Gossels,
we are
just-
governed, and this is one of the principal issues in this case.
Mr.
We have-
Gossels, just so that I'm clear,
Sorry, yeah.
are you making this argument here for the first time?
I am not.
Because it's not cited in your brief and it's not in the appendix. So you've made the 3104 argument somewhere before?
I believe I have.
Okay. All right, I just want to make sure.
Please forgive me. In any event, I came into the bank bearing this check denominated in euros. My understanding is that I was entitled to euros, and that's what I expected.
And did you put in evidence of that at the trial level? That
Yes,
you
I did.
said-
That was in evidence. I was at the trial, and the trial judge so found.
But, so when the appeals court said there was no evidence that you communicated your desire to be paid in euros, is that just incorrect?
I think that's incorrect.
Did you
That's an-
communicate it? Not what you, did you
I
communicate?
understand that. I'm not absolutely sure that I communicated it, but I believe I did, and I believe it was in evidence at the trial.
You believe you
But
communicated it to the teller?
Even if I didn't, let me pull back from that, not make an issue of that, because I don't think that's important. The important thing is not the 175 years of custom and usage that my sister here talks about, but General Laws Chapter 106, because General Laws 106 was enacted in this Commonwealth in 1957, long after these decisions of this court. And it's 106 that governs, and not usages in the Commonwealth prior to that time, or the rules and regulations of this bank. And that's critical in this case, because
So
what
is it, besides 3104, is there any other sections of the code?
absolutely. If you take a look then at 3107, if you look at all of 106, you'll find there are only 2 sections that have to do with foreign money.
But
And those
doesn't-
sections, I'm sorry?
You go ahead, I'm sorry.
Yeah. And those sections are 3107 and 214F. Those are the only ones. So when I brought when Dresdner paid the euros came to Boston. They were actually here on the books of the bank. When they came here, the question is, what right did Fleet have to exchange those monies? They had no right to do it except for those two sections of the law, 3107 and 4214F.
But 30107 doesn't apply to a collecting bank, does it?
Certainly does, because there's no other. 3107 is the only statute that allows the exchange of money, because under the 106, you have to pay the person a fixed amount of money. And only in 3107 do you see a reference to foreign money. None of the other sections refer to that. So foreign money comes in, they should have given me the money. They should have given me the euros. You can go into any Fleet Bank or any Bank of America and ask to buy euros, and they'll sell them to you. And the record is clear that they were in the arbitrage business on top of it. That was part of the trial. It came up at the trial. So therefore, if they chose to pay me in dollars rather than in euros, they had to find some authority.
What authority do you have for saying that Section 3-107 applies to Fleet as a collecting bank?
Because it says, and it refers to the instrument, unless the instrument otherwise provides an instrument that states the amount payable in foreign money may be paid in the foreign money.
Well, even if it does apply to Fleet, doesn't it give Fleet the option of paying in
Yes.
domestic currency?
Yes, it does. But here's the key to this entire case. If you look at the statute, it says may be paid in foreign money or in an equivalent amount of dollars calculated by using the spot rate of Dresdner. The words equivalent amount of dollars are the critical issue in this case, because what Fleet intended to do and did do is to reduce the amount, that is the equivalent amount, by 4%. And they gave me only 96% of the amount that the statute insists I'm entitled to. They had a right to pay me in euros, or they had a right to pay me in dollars. But if they're going to pay me in dollars, which they had a right to do by reason of 3107 and the other statute I cited, then they had to give me 100% of the equivalent value. They were entitled to deduct their collection fee, which in this case was $30. But otherwise, they had to give me 100% of the equivalent value, and that's what it says in 3107.
Mr. Gossels, the trial judge didn't reach 3107, and my memory is the appeals court did and rejected your argument. And
No, it did not.
On 3107?
Absolutely.
It said it did not apply.
Let's see if I can find at pages, I'm referring now to the appeals court decision.
Oh, it said that.
It said, here in the court, all right, at the top of 812B, it says, here, in accord with General Law, Chapter 106, 3107, the check was payable at the Dresdner Bank, either in euros or in dollars, at the current bank offered spot rate at the place of payment for the purchase of dollars in the day in which the instrument is paid. Because Fleet had not disclosed all material facts concerning the amount it would deduct for itself from the check proceeds, including the rate at which it would pay him, there could be no agreement with respect to a different rate that could be paid to Gossels had the check been properly processed by Fleet. Fleet, therefore, would have been obligated to pay Gossels in accordance with the spot rate at Dresdner Bank, October 15th, less service charges, so calculated the difference was $10,269. So the appeals court did so find, and of course I stand on the conclusion of the appeals court. But this is the critical point that I think is before this body this morning. After, as I said, 7 years of litigation here, the question is, can a bank, which is governed by 106, how can they say that 106, 3107 doesn't govern them? All of 106 governs them. The general court has enacted that statute in order to govern the conduct of banks with regard to consumers. I'm a consumer, you're a consumer, all the people in this room are consumers. That's what 106 is about. And they say, well, 106 doesn't apply to us. They also say 93A doesn't apply to them, but it does. 93A does apply to them. And let me just remind you of the paradigm here, or at least the regulation which I referred to in my brief, which is, oh gosh. Oh, yes. 940 CMR 316. It says that, in that regulation, it says that a practice is a violation of General Laws, Chapter 93A, Section 2, if, and you notice that this case falls right on it, any legal entity which fails to disclose to a prospective buyer any fact, the disclosure which may have influenced them not to enter into the transaction, or if it fails to comply with existing statutes, rules, regulations, or laws meant for the protection of the public welfare intended to provide consumers of this Commonwealth protection. That regulation, I believe, is the paradigm by which the conduct of fleet should be measured, and they fail on both counts. Number one, they didn't disclose to me that they were going to take 4% of my check, of the proceeds of my check, and number two, they violated a whole bunch of Chapter 106 sections and regulations concerning the processing of the check. Now, you asked earlier in your questions to my sister over here about damages. There's a lot of talk in the briefs about the endorsement, and of course that was important, and I'm not insisting very much about it, but the fact that the teller told me not to endorse the check did result in the fact that the check was returned. Forget all of the nuances of this, but I didn't actually...
What was wrong with what the teller told you?
If I had endorsed it, it would have been...
No. What is wrong with saying the check can be negotiated, or that the check can run through the collection process and without an endorsement?
She didn't say that. She just simply said, don't endorse it. I was on process of endorsing.
What if she's correct? What if she is correct? That's what the bank said.
Well,
absolutely correct, and the bank in Germany upon which the check is drawn blew it.
In my brief, I refer to UCC comments saying that in the event that this happens and the collecting bank has a corresponding bank, which is what happened here, that it had selected.
Did the corresponding bank reject it, or did the actual payor bank?
No, it was not. It was the corresponding, the Deutsche Bank.
So
Fleet should have actually sent the bank right to the payor bank, Dresdner, but they didn't do it.
So what you're saying is Fleet itself actually rejected the check. It's corresponding bank, not the payor bank.
Exactly, because the corresponding bank was the agent of Fleet. And the UCC comments that I've cited in my brief make it clear that Fleet was responsible for the conduct of the corresponding bank, Deutsche. And they're the ones who returned the check. And that was a month later.
And then they returned it because it had not been endorsed.
Well, it's part of the record. In fact, Deutsche Bank said, we can't take this check and send it over to Dresdner because it hasn't got an endorsement on it. And so they send it back. I won't go into all of the things that happened, but essentially that happened. So during the course of the 2 months that expired, if you like, for the collection of the check, the euro dropped. And I say that is damages to which I'm entitled.
So Fleet is responsible for Deutsche.
For Deutsche.
Deutsche's bank error.
Yeah.
Deutsche Bank's error, Fleet is responsible.
Yes, it is.
Is that the essence of your argument then? Does your argument boil down to that?
No, it's number one, the instructions not to endorse led to the drop of the euro.
Let's assume that's correct. Instruction not to endorse, that's correct instruction.
Yeah,
Let's assume it's a correct instruction.
Let's assume it's correct, but it resulted in conduct by an agent of Fleet that cost me 8% of the value of my money.
So that's what I'm asking. I'm asking that in essence that's what your argument boils down to, is that Fleet is responsible for the actions, the conduct of its correspondent bank.
Exactly. And that's what I've cited authority for that.
Your account had been credited for $38. Wasn't your account credited for $38.25?
Yeah, well, there was a little bit of interest, that's all. That wasn't, had nothing to do with the drop of the euro. That was, I went in there and I said, hey, look, you told me not to endorse this. What's going on here? You know, this is, I'm dealing with a bank officer here, and they said, well, all right, I realized that we made a mistake. And they did say that, and it's part of the record of this case. And she said, I'll return you the $38.
Mr. Gossels, may I ask you this? When was payment made to Fleet?
To Fleet, I don't know. but they paid me on December 15th.
I thought that they were paid on December the 15th.
They say so, and I have no evidence to the contrary.
So they were paid on December the 15th, and you were paid on December the 15th.
That could be.
Well, were you paid on December the 15th?
Yes, I was, but not what I was entitled to. And I want to make clear that the damages are not only caused by the drop of the euro, but also the 4% that they took. They had no right to take the 4% in the light of 3107, as I argued earlier. But I think the critical thing here is we're all talking about Peter Gossels here because I happen to be before you. But I believe that as a consumer, I represent many other people in this Commonwealth who need protection from this court. I appear before you now after 9 years of struggle with this bank, which has taken these things, and the appeals court found, for that matter, the trial judge found in my favor, the appellate division found in my favor, the appeals court found in my favor. The only issue was how much. But in all of these cases, a consumer had to work for 9 years against an institution like this bank and spend thousands and thousands of dollars in attorney's fees, and I can't tell you the aggravation. I filed, I think, something like 6 briefs in this case. First before the trial judge, then the appellate division, then the appeals court. There are 3 briefs before you now. All of this I had to do to point out to this court that consumers need protection that the general court has given them. And you heard my sister this morning say, listen,
Mr. Gossels.
I'm sorry?
No. I was letting you finish your point.
I'm trying to finish.
But while you're moving to a new point, I think your time is up.
I'm sorry?
No, but we thank you for your argument.
Thank you for your patience with me.
We'll take a short brief, a short recess.